You see, large scale development has been going on across Goa. Hills are being cut, forest land is being denuded, and these are things which have agitated people all across Goa. The entire landscape of Goa is being changed. Section 17(2) of the Town and Country Planning Act, when it was introduced in the Legislative Assembly, I had specifically asked a question as to why this amendment was being done, because it was claimed that it was for correction of errors in the regional plan and to empower the Chief Town Planner to make changes in the Regional Plan 2021 without any public consultation. At that time, the Honorable Town and Country Planning Minister told me that this amendment was necessary because there were errors in the 2021 RP and therefore it required correction. However, I pointed out this piecemeal corrections would lead to zone changes by the back door, and it would be better to have a regional plan, which means a new regional plan finalized. And the Honorable Minister replied that this amendment was to help genuine cases of zone changes and the new RP would take time. What we have seen thereafter is that huge tracts of lands started getting zone changes under the guise of correction, and the entire topography began to change without public consultation, and villages were being urbanized overnight with elected representatives, panchayats, local bodies, and even the people being kept in the dark. Naturally, the citizens came forward and challenged this law, including Goa Foundation, led by Senior Advocate Norma Alvarez and Dr. Cloud Alvarez. There have been other petitioners, including Rainbow Warriors, Abhijit Prabhudesai, whom all of you would know, and Swapnesh Salekar, the other one who is an activist in this field, along with others who have filed a petition. Today, the Bombay High Court, while rejecting the challenge to the constitutional validity of this amendment, read down section 17(2) and quashed the rules and guidelines. The court emphasized the need for a planned development, and in paragraph 24, the High Court held thus: hence the following order. The relief claimed by the petitioners for declaring section 17(2) of the TCP Act 1974 as unconstitutional is rejected. Section 17(2), however, is read down to avoid the vice of arbitrariness and hostile discrimination by interpreting the expression inconsistent or incoherent zoning proposals to mean inconsistency or incoherence in a zoning proposal with respect to another proposal in the RP or with respect to the outline development plan. It would in no case imply change of zone of a parcel of land having regard to its peculiar features. Secondly, the Goa Town and Country Planning alteration / modification in the regional plan for rectification of inconsistent, inadvertent zoning proposals rules 2023 are struck down, being ultra vires the provisions of the Constitution and the TCP Act, thereby rendering the guidelines for alteration / modification to be carried out under section 17(2) issued by the Town and Country Planning Department with the circular so and so dated 27 March 2023 null and void. Third, it is made clear that we have only considered the challenge to section 17(2) of the Act and the 2022-2023 rules. List the petition for further consideration after 4 weeks. At this stage, Mr. Devitre, learned senior advocate for the state, requests for stay of this order. Considering the nature of the challenge, we stay the operation of this order for a period of 6 weeks. However, we make it clear that there shall be no consideration of the applications for approvals made under section 17(2) of the Act. So, in plain language, what does this mean? Firstly, reading down is a technique by which the law, which otherwise would face invalidation, is saved by supplying it with conditions to make it statutorily or constitutionally valid. Second, and that is where the High Court has used these words, the expression inconsistent or incoherent zoning proposals to mean inconsistency or incoherence of a zoning proposal with respect to another proposal in the RP or with respect to the outline development plan. It would in no case imply change of zone of a land parcel having regard to its peculiar features. Secondly, you have heard me saying that the rules which have been framed have been quashed and have been struck down. And thirdly, the guidelines issued are also declared null and void.